Now, the legal representatives of the African National Congress have written to the founder of the uMkhonto weSizwe political party demanding that it cease to use the MK name and logo, or legal action will be instituted. Now, former President Jacob Zuma announced his endorsement for the uMkhonto weSizwe party in the 2024 general elections when it was registered with the IEC in September. The ANC argues that the name is a trademark of the party's now disbanded uMkhonto weSizwe War Veterans Wing. Let's get some insights on this with the legal analyst Mpumelelo Zikalala. Very good morning to you, Mpumelelo. Thank you for your time. The ANC is concerned about the use of uMkhonto weSizwe's logo and trademark, giving the new MK party a deadline. Stop using the name. How serious of a threat is this?
Good morning to you, Mundisa, and also to your viewers. It is very serious. Remember that your identity is the only thing that you can be identified by, and it means ultimate protection, whether it's your direct identity like the African National Congress or some of the names in which you may be referred to, in this case, or closely associated with you, in this case, uMkhonto weSizwe, then anything which is going to tamper with it, that is going to may ruin its reputation, then comes in. In fact, our law takes care of that in terms of saying under the Trademarks Act, if you're going to use a trademark that I'm using, manipulate it here and there and represent it as that of your own, it is an infringement. Also, the common law takes care of that in two instances. One, where it's considered that you are now passing over or you are closely resembling what the logo that represents me. And on that basis, you are now damaging the reputation that I have. So in this instance, I think the ANC has every right to say to the newly formed party, we have the name uMkhonto weSizwe. The logo is similar to ours. There's a rich history pertaining to what the name uMkhonto weSizwe means. If you look at our documents, for example, you would see those particular names being there. And any other individual who is going to pass over that particular logo, not concentrating on the finer details of it, may be confused to think that it's the original logo of uMkhonto weSizwe and not that of the new party. And on those bases, they have every right to go to court to say, we want to protect our intellectual property, so that it's not exploited by any other individuals other than us.
The ANC lawyer is saying that the new party has also been launched with the logo and the block letters of uMkhonto weSizwe, which may lead South Africans to now believe that there's a connection between the two. What kind of considerations will be needed here as this threat has been put out to say, come 29 December, you better make sure that you're not using that name anymore?
The first one is the resemblance between the two sort of logos or the trademarks that are there. How resemblant are they? How identical are they? Is it to clearly identify one from another? Or is it a situation where they are so closely identified to such an extent that a layperson or a person who is not looking at them with a magnifying glass will not be able to see the difference? That's the first one. And then secondly, you then think, what are they doing with that particular logo and which arena are they trading in? Now, there are both political parties, both politically contested terrain. We are going to elections next year. So the existence of a certain political parties got an impact of either decreasing or increasing the votes which are now attached to you. Now, if you are going to have a logo which closely depicts anything that resembles to you as a political party, you do not want that because you want to protect your logo at all costs, regardless of the fact that the historical context that you would want to protect, you don't want that particular context to be detained or to be diluted in any manner. So in this case, they do have a case in terms of saying, well, you are in the same terrain or in the same market as us in terms of allowing voters to vote for you. Do it on your own. Nothing is stopping you from doing that. But do not use the tools of trade. Do not use the logos which are associated with the political party that's existed for a number of years.
What case can the MK party, argue in this matter? I mean, does it matter whether or not uMkhonto weSizwe was disbanded? Will it matter who registered the trademark first? Is that something that the court will be taking into account?
Yes, the court will take that into account. Remember, there is a registered trademark that is there. So if you look at that particular logo, the one thing which may be working in favor of uMkhonto weSizwe is the name, which is there, in terms of saying, well, the name has not been registered to any individuals, or there's no proof that the name is registered. The only thing which is contested is the logo. So if we change the logo and change the colors, then there's nothing stopping us from continuing with that. We may still have the spear, we may still have the man, even the shield may still be there. However, the design, the manner in which you are holding that particular shield and the spear may change. And if that changes, and there's clear identification between the uMkhonto weSizwe of the ANC and the uMkhonto weSizwe of the new political party that has been created, then they would be trading on the right side of the law. But other than that, I do not think there's anything that may be in their favor, especially when it comes to the logo and the design. It is closely related or resembles that of the uMkhonto weSizwe that existed. And for the African National Congress, that particular logo has been registered. So there's protection that is there, and the law offers protection to the ANC to say nobody else can be able to use that particular trademark while it still belongs to the ANC.
And the other matter is a lot of reactions on former President Jacob Zuma's actions, some saying that this is all a form of gross ill discipline, saying that he'll vote for one party yet remaining committed to the ANC. How do you see that playing out in terms of legal standing on Zuma's choices?
Well, on the basic principle, your allegiance has got to be one, to go to one political party. You can't vote for two. Well, you can choose to maybe share your votes in terms of the ballots, but if you say you are a member of a certain political party, that means you subscribe to the constitutional provisions of that particular political party. Now, it would depend. Is there a provision within the ANC constitution that says you can't belong to another political party? What then happens if you publicly share your sentiments as to your allegiance to another political party except the ANC, what sort of repercussions are there? But we must also look at it within this instance. Here, we are not dealing with an ordinary member. We are dealing with an ex-president, someone that has served that particular political party at their highest behest. And you wouldn't think that at any given point in time they'll come back and say, don't vote for the party that I've led for a number of years. Don't vote for a party in which I've advocated and promoted and requested you as members of the public to vote for it. So what has changed now? So if you're not going to be in allegiance or don't share the same sentiments as that particular political party, then you must leave it and go and form your own one or find a new political home. But not to say I'm going to remain here and then go to another political party and vote for another political party. It then falls upon the current leadership of the ANC to say, are we going to enforce the provisions of our constitution? There are clear ways in dealing with such matters. And disciplinary matters are supposed to follow. But another side of the coin is that you do not want to give political mileage or media or publicity mileage to a particular process, which may end up derailing you from the elections which are right there on your doorstep. So I think the ANC is taking the approach of saying, let's deal with the logo because that is what this party is important. What I do anticipate, though, is that even an IEC challenge is going to come in which they would come in and then say, electoral IEC, please go and look at this political party. The logo is not supposed to be there. It resembles something which belongs to somebody else. When it comes to the ballot, if they do end up in the ballot papers, then their names must not appear, or even that particular logo must not appear in the ballot box. And that way it matters most by them.
What does this say about the IEC's guidelines and rules? Surely that, this sort of duplication should have been red flagged or filtered. What does it tell us about how the IEC's guidelines are placed?
Remember that the IEC will play the role of the innocent bystander. So they would say, here's a person that wants to register this particular political party. We are sending it to you as your own duty as other political parties that are in existence to lodge those objections that are there. The IEC Act is very clear pertaining to that. But there's still an opportunity for the ANC to then say, we are lodging an objection to the Commission, and if you're not going to give us any reprieve, then let's go to the Electoral Court that will deal with this matter in a much more fast and protected way, so that by the time we come back to the elections next year, this matter would have been done and dusted. But for the role of the IEC, it does not play the role of being the enforcer or the protector of any of the rights of any other political parties that is there. It simply says anyone that wants to register a political party must come to me. Once that has been done, I'll then send whatever processes or publish it in the government gazette, and it's up to those affected individuals to then come back and say, please stop the registration of this political party because it's infringing on us. I think the question should be, what did the ANC do when it came to their attention that there's another political party which is there? Were they even looking at the type of political parties that are being launched on a daily basis, or it is a situation where they were caught napping pertaining to that particular part? But the door isn't closed as yet. The only time in which you can say that this matter is done and dusted is when there's a court order that comes from the Electoral Act that says, ANC, you can't stop these individuals from trading using the name uMkhonto weSizwe, and that's where it ends. I think that's why they even chose the trademark route, because it's much more easy and much more quicker than going the IEC route.
Yeah, because what's also concerning here is that, as I read in Mpumelelo from the statement saying that our client has applied for registration of the marks uMkhonto weSizwe under application number so-and-so in class 41 and uMkhonto weSizwe war veterans under another application in class 411. So that in itself, is this a registration pending on top of another registered party in the same name?
It would be. Ordinarily, you would find that entities would have their main name and they would have defensive names. So when it could be manipulated and you don't want anyone to manipulate your name, and you don't want to risk the process of going through the court process and trying to prove through common law and the Trademarks Act, because it belongs to you and the potential that it might have in confusing your market or the people that you want to vote towards you, then you may find defensive name being registered, which may be what the ANC has been doing with registering uMkhonto weSizwe veterans or any veterans league or any indication of the name veteran in anything which is associated with them. So it may be that there are applications which are still pending, they are not finalized. If that's the case, then you cannot use the Trademark Act effectively, because that particular right has not been conferred to you as yet. However, there are common law principles which are applicable. And when you look at common law principles, yes, it says registration is the ultimate form of protection. However, if you can prove that there's been a reputational existence, historical association with the name associated with you, then there will be reputational damage at the end of the day. If you do not deal with this misconception, then as per common law, your rights are protected despite the fact that there was nothing which was registered under the Trademarks Act. So the ANC is doing what is correct, making sure that the registration process is done correctly, but they still have a defense using common law to say this is where we are. But I think it's going to open the eyes of the ANC and other political parties to say, be careful of your laws. Make sure that you use these laws to protect them, because the last thing you want to do is to fight over a particular name during the festive period, especially in the eve of elections taking place in 2024.
Yeah, absolutely. Thank you so much for that insight, legal analyst Mpumelelo Zikalala, giving us a sense of what the ANC's threat, legal action against the MK party over uMkhonto weSizwe, trademark would entail.